I came home from a late shift to find a construction fence erected directly across the entrance to my own driveway, blocking any possibility of pulling in, with a laminated notice zip-tied to the fence explaining that temporary access restrictions were in effect due to ongoing Ridgemont Luxury Collection construction activity. A notice that offered no phone number, no timeline, and no acknowledgement whatsoever that the driveway in question happened to be the only vehicle access point to my own private home. My name is Desmond Ichterberg. I've lived in my house for 14 years, on a lot that predates the surrounding HOA-governed community entirely, my property having originally been part of a small cluster of older, individually owned homes that existed on this land well before Ridgemont Estates was developed around us over the following decade. I want to establish clearly, because it matters enormously for everything that follows, that my property has never been part of the HOA. I pay no dues, hold no membership, and have never been subject to any of the community's governing declaration, a status that had, for the entire 14 years I'd lived there, functioned smoothly enough. My driveway simply accessed via a shared private road that the original development agreement had designated as a perpetual easement benefiting my property specifically, predating and legally superseding any authority the HOA would later claim over that same road. I want to walk you through how this situation escalated, because it began, as these things often do, with something that initially seemed like a minor and temporary inconvenience rather than the significant legal fight it eventually became. About 8 months before this story reaches its climax, the HOA board, under a president named Priscilla Wentworth Ashcombe, approved a major new construction phase, marketed as the Ridgemont Luxury Collection, 22 high-end custom homes planned for the community's remaining undeveloped acreage, a project that generated considerable excitement among the broader HOA membership, given the anticipated boost to overall property values. I received an initial notice, several months before the driveway blockage itself occurred, informing me that construction traffic for the Luxury Collection project would be routed through the same shared private road my own driveway accessed, and that temporary inconveniences might occasionally occur during active construction phases. I want to tell you that I did not object to this initial notice, understanding that some reasonable degree of construction-related disruption was a normal part of living adjacent to any active development project, and that I fully expected any actual access restrictions to be brief, well communicated in advance, and considerate of my property's legal right to that road. What actually happened, on the morning I came home to find my driveway entrance fully blocked with no advance warning whatsoever, was considerably different from anything that initial notice had described. I called the number listed for the general contractor overseeing the Luxury Collection project, and the representative I reached explained that the fence had been erected to secure a staging area for heavy equipment delivery expected over the following several days, and that they had been informed, by the HOA itself, that the affected section of road fell entirely within the association's authority to restrict as needed for construction purposes. I want to sit with that explanation for a moment, because it revealed something important. The contractor had been told, apparently by Priscilla's board directly, that they held full authority over that road section, a claim that, given my property's legal status entirely outside the HOA and my specific, recorded easement right to that exact stretch of road, was simply not accurate, regardless of how confidently it had been communicated to the construction crew actually executing the blockage. I called Priscilla directly that same evening, explaining the situation and requesting immediate removal of the fence blocking my only vehicle access point. Her response, delivered with a confidence that struck me as genuinely detached from the actual legal reality of my property's status, was that the road fell under the HOA's General Maintenance and Access Authority, and that reasonable temporary restrictions during major construction projects were within the board's discretion, regardless of any individual property's specific access needs, and that I should expect the current restriction to remain in place for several more days, while the equipment staging was completed. I want to walk you through the research I did that same evening, because I wanted to be absolutely certain of my own legal standing before deciding how forcefully to respond. I pulled the original recorded easement document from the county, filed decades earlier when my property and the small original cluster of homes around it were first established, well before Ridgemont Estates or its HOA existed at all. That document confirmed exactly what I'd remembered: a perpetual, non-revocable easement specifically granting my property continuous vehicle access rights to that exact stretch of road, a right that predated, and per basic property law principles, legally superseded any authority the subsequently formed HOA could claim over that same section, regardless of what governing declaration language the association's own more recently platted portions of the community might contain. I want to introduce you to my neighbor and longtime friend, an attorney named Rosalind Farah-Kowalski, who specialized in property and easement law, someone I'd actually consulted years earlier when I first moved in, specifically to confirm exactly this kind of access protection, given how the surrounding development had grown up around my originally standalone property. Rosalind reviewed the current situation, the fence, Priscilla's claimed authority, and the original recorded easement, and told me something that reframed the entire dispute considerably. "Desmond," she said, "this isn't a close call. Your easement is recorded perpetual and predates the HOA's own formation entirely. They have no legal authority whatsoever to restrict your access to that road, for any reason, temporary or otherwise, without your explicit consent. What's happened here is straightforward interference with a legally protected property right. And frankly, given that this is directly connected to an active, high-value luxury construction project generating considerable revenue and reputation for the association, I think we have real leverage here to make sure this gets resolved considerably faster than Priscilla currently seems to expect. I want to tell you about the decision Rosalind and I made that evening, because it turned into something considerably more consequential than simply demanding the fence's removal. And it's the reason this story ends not just with my driveway restored, but with an entire luxury development project brought to a complete, court-ordered halt, until Priscilla's board was forced to reckon with exactly how many legal corners they had apparently cut in their rush to get the Ridgemont luxury collection moving as quickly as possible. Rosalind's first move was filing for an emergency temporary restraining order requiring the immediate removal of the fence blocking my driveway. A filing that, given the clear, recorded, decades-old easement documentation, the court granted within 2 days, forcing the fence's removal and restoring my access almost immediately. But Rosalind told me, once that initial emergency relief was secured, that she wanted to dig further into how this situation had actually happened, because a construction crew being told, apparently by the HOA itself, that they held unrestricted authority over a road section they demonstrably did not control suggested a level of carelessness, or worse, that she felt warranted closer examination before this dispute simply concluded with my driveway restored and nothing else addressed. I want to walk you through what that further investigation revealed, because it turned out to matter enormously for how the rest of this situation unfolded. Rosalind requested the full construction permitting and traffic management plan the general contractor had filed with the county for the luxury collection project, documents that were required, under standard county development regulations, to explicitly identify and account for any existing legal access rights or easements affecting the project's designated construction routes. What those permit filings showed was that Priscilla's board, in submitting the project's traffic and access plan to the county, had explicitly represented that the shared road serving the construction route was entirely under the HOA's own governing authority, with no competing legal access rights or easements affecting it. A representation that, given my own clearly recorded and legally superior easement, was simply false. Whether through genuine ignorance of my property's actual legal status or a deliberate decision to omit an inconvenient detail that might have complicated the permitting process. This is a significant problem for them, Rosalind told me, once she'd fully reviewed the permit filings. County construction permits, particularly for a project of this scale, require accurate representation of existing access rights and easements as a condition of approval. If the board knowingly, or even carelessly, misrepresented your property's legal status in order to secure this permit, that's not just a civil matter between you and the HOA anymore. That potentially exposes the entire project's permit to challenge, and given how aggressively they move to block your access without ever verifying their actual authority to do so, I think a formal challenge to the permit itself, on the grounds of material misrepresentation, is worth pursuing alongside your own personal claim. I want to walk you through the decision to actually pursue that broader permit challenge, because it was Rosalind who framed the strategic reasoning clearly for me. A challenge focused narrowly on restoring my own driveway access, while completely justified and already substantially achieved through the emergency restraining order, would do little to prevent the HOA from simply continuing the same pattern of disregard for my easement rights throughout the remainder of what was expected to be a multi-year, phased construction project. A formal challenge to the underlying construction permit itself, however, citing the material misrepresentation about existing access rights, carried the potential to force a considerably more comprehensive and lasting resolution. Rosalind filed that formal permit challenge with the county's Development Review Board about 2 weeks later, and I want to tell you, the response moved considerably faster than either of us expected, largely, I think, because county permitting authorities take fairly seriously any indication that a development project's approval was secured through inaccurate representations about existing legal access rights. A category of issue that can create genuine liability exposure for the county itself if a permit is later found to have improperly disregarded a valid, recorded easement. The county's Development Review Board issued a formal stop work order on the entire Ridgemont Luxury Collection project within about 3 weeks of Rosalind's filing, halting all construction activity pending a full review of the permit's accuracy, and a formal resolution of how the project's traffic and access plan would need to be revised to properly account for my property's legal easement rights going forward. I want to walk you through the chaos this generated within the HOA itself, because a complete construction halt on a 22-home luxury project, one that had already generated substantial buyer interest, and deposits similar to other large development disputes I've heard about from friends dealing with their own HOA situations, created exactly the kind of visible, expensive, and deeply embarrassing consequence that forced the board to finally take my original, simple demand. Respect for a legally recorded easement, considerably more seriously than Priscilla's initial dismissive response had suggested she was inclined to. An emergency board meeting was called within days of the stop work order, and I want to tell you, though I did not attend personally given that my own legal position was already well established through the ongoing litigation, Rosalind attended as an observer and described a room considerably less confident than the one that had originally approved the luxury collection project 8 months earlier, board members now facing direct, pointed questions from residents who had watched a supposedly prestigious flagship project grind to a complete, publicly documented halt over what increasingly looked like Priscilla's own failure to properly verify basic legal facts before proceeding. I want to walk you through how this ultimately resolved, because the stop work order created exactly the kind of leverage Rosalind had anticipated when she recommended pursuing the broader permit challenge rather than simply settling for my own driveway's restoration. The board, facing mounting pressure from frustrated deposit-holding buyers, and a construction contractor incurring significant delay costs, agreed to a comprehensive settlement, formally and permanently acknowledging my easement's full legal priority over that road section. Revising the project's traffic and access plan to properly route construction traffic around my property entirely, rather than through the shared road my driveway depended on, and compensating me directly for the disruption and legal costs the original driveway blockage had caused. I want to tell you about the moment the stop work order was finally lifted, once the revised access plan had been properly reviewed and approved by the county, because I remember watching construction traffic resume along a newly designated route that curved well clear of my own driveway entirely, a considerably more expensive and logistically complicated routing for the contractor than the original plan had been, but one that finally, properly respected a legal right that had existed on paper for decades before anyone ever tried to simply pave over it with a temporary fence and a vague notice. Priscilla, facing considerable community frustration over both the original driveway incident and the resulting weeks of costly construction delay it had ultimately caused, did not run for re-election when her term concluded a few months later, a decision that, I understand from neighbors who remained in the HOA, was widely seen as an acknowledgement that the entire situation had become simply too damaging to her standing within the community to continue leading it. If there's a lesson in this story, I think it's something Rosalind said to me during one of our early meetings, reviewing my original decades-old easement document alongside the HOA's own permit filings for what felt like the 10th time. She said that HOA boards, particularly ones eager to move quickly on a high-value, prestigious project, sometimes proceed on convenient assumptions about their own authority rather than pausing to verify the actual legal landscape they're operating within, a shortcut that can work quietly for years right up until it collides with a property owner who actually knows their rights and is willing to enforce them. At which point, the entire carefully built momentum of a major project can come to a considerably more expensive and public halt than anyone rushing it forward ever anticipated. We enforced our rights, and it turns out that one decades-old recorded easement, one attorney who understood exactly how to escalate beyond a simple driveway dispute into a full permit challenge, and one luxury development project that ground to a very public, very costly halt, were more than enough to make sure Priscilla Wentworth Ashcombe's flagship achievement became, instead, the exact reason her own community finally decided they'd had enough of her leadership. Thumbnail text. She blocked my drive, so I stopped them.